Hello, everyone, and welcome back to Immigration Talk Show. I'm Nipasa, and I'm going to be your host for this session that's lined up for you. And before we head on with today's discussion and also have our guest join us for today's webinar, I have this very important disclaimer to read out. So, by watching our videos, you agree and understand that information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. I hope you keep that in mind, friends, throughout this whole session. And I would like to tell you that you can also be a part of this session by commenting wherever you're watching us and also by calling us on this line where you can dial in. And the number is 425-436-6335, and the access code is 988-888. Absolutely. As you can see, the topic of discussion on the screen already, we are going to discuss about what are the do's and don'ts for the H1B cap. And it's going to be very interesting a session. And most of you may have questions. So please feel free to join us with your questions. You can comment your questions or call in to ask. And also, if you're being thoughtful enough, share this link with your friends where they can also join in, especially if this is something they could benefit with. So share it, friends, with your friends and family, and let's do this together. And absolutely, without any further ado, please help me welcome our guest for today, Attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. Hi, Prashanthi.
Hello, hi Nipasa, how are you?
I'm doing good, Prashanthi. It's always good to have you, and welcome back.
Thank you.
So, friends, Attorney Prashanthi Reddy has been practicing immigration law here in the US for almost 3 decades now. So, you should definitely go check her out. And if you need a one on one consultation, why not contact her as well? Her number is 212-354-1010, or you can email her at prashanthi at reddyesq.com, or go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy. So, yes, since it is the cap season and this is a very, very important topic of discussion, many of you have questions, especially with all the updates and this and that every day. We have a new thing, especially with immigration thrown at us. So, Prashanti, what would you like to tell folks out there before we start today's session?
Um, yeah, it's really hard to keep up, as you said, because something new is happening every day and not in a good way. I wish it was. Um, but and we are getting blindsided and losing focus with reference to our regular, immigration work with reference to H1Bs, etc., because something or the other is coming up. But we have to keep in mind that there is regular work to be done, and we shouldn't lose sight of that. And it's business as usual for the H1s. So, a lot of people filed registrations this year. People thought that there'll be very few registrations filed, but that was not the case. It might be slightly lesser than last year, but it's not that much less. So, there is still demand. Companies still need employees, and they have enough business to require new employees. Um, we also have to keep in mind that the deadline for filing your H1B cap is fast approaching. So we decided to, go back on track and get back to our regular business of filing H1Bs and other work visas for our clients as they need them. With the whole, student CVIS termination, things seem to have been resolved in a positive manner. We can get back to, as I said, our regular work. So we thought we'll talk about, the H1B cap again and the do's and don'ts, so that we can help employers and employees navigate, their H1B filings this year, which have to be filed before June 30th. So let's get right to it.
Absolutely, Prashanti. And June 30th may seem like a long time, and you may think that you have a lot of time in hand. But I think I would like to say, friends, that don't keep everything till the end. Work on it while you still have time so that if there's anything more to work on, you'll have time later. So, yes, Prashanti, let's go ahead. So, if you could tell us, some of the most common mistakes that can lead to H1B registration denial.
Registration denial. Since we're already done with registrations, I think let's talk about the actual cap, right, Nibasa?
Okay.
Um, so let's go to a question that addresses the H1B petitions rather than registrations.
Okay. Sure, Prashanti. But would you like to tell any of the common mistakes that they should avoid, while they are in their petitions?
While filing a H1B petition, you mean?
Yes. Is it allowed? Can you hear
Yeah,
me?
yeah, I can hear you. So, yeah, since the registrations are over and we don't have to worry about them until next year, let's talk about the actual filing of the H1B petitions.
Mhm.
And your question was, what are the common mistakes to avoid
Some
while filing?
some common mistakes, right? Some common mistakes that can, lead to denial of the whole petition also.
Right. So, one of them that I can mention, and we can go over a whole laundry list of items, but one that comes to mind is not paying the correct fee. USCIS fee is very complicated, especially for H1Bs, depending on the number of employees you have, depending on whether you are, um, a nonprofit, uh, or you are a for-profit organization.
Mhm.
The fees change, and there are many different kinds of fees, and all these different kinds of fees change. So it's very complicated to put it shortly. So it's important to know what the fees are. Number one, so contact your attorney to find out what the correct fee that you need to pay is, or at least do proper research to see what it is. And not only the fee changes depending on your number of employees that the company has, it also there are different fees, different kinds of fees applicable in different circumstances as well. So if it's an extension, it's a different fee. If it's a cap petition, it's a different fee. If you're over 25 employees, it's a different fee. Under 25 is a different fee. If you're a nonprofit organization, there's a different fee. So as you can see, and there are various different, there's an asylum fee, there is ACWIA fee, there is, a fee, the regular H1B fee. So, it's just so complicated that sometimes even I get confused. So make sure you know what the different fees are and make sure which fee is applicable to you and how much you need to pay. The second, again related to fee itself, is write the check properly once you've determined what the fee is. Make sure you put in the right fee amount. If you're especially filing by mail, put in the right amount, sign the check, date it properly, put it in numbers, and so often um, cases get rejected. And we're talking here not about how to avoid an RFE, but how to avoid rejections from the mailroom itself. And this is one of the reasons for rejections. It doesn't even go to an officer if you don't put a proper check or the proper fees. Another reason why it would get rejected in the mailroom is if you don't send it to the right address. Sometimes they do forward it to the right address themselves, but oftentimes they will just send it back. Third reason, if you're not filling out uh, tick marking certain boxes, especially with reference to fees and cap exempt and start dates, then they will just send it back from the mailing room itself. Because you might have sent the correct fee, but you might have marked the wrong box, so they think that you sent the incorrect fee. So that's another reason. Third reason is if you have not signed the petition. Even if one place, there are several places where the I-129 petition has to be signed by the employer, and if you miss out signing even in one place, then they'll send the entire petition back. They will not send an RFE. So that's another common mistake. And remember, the address is very simple for cap cases. You just have to follow your registration notice to find out what the address is. So these are some of the common mistakes that can lead to the petition coming back from the mailroom itself.
Thank you so much, Prashanti, for going through all of these very important points that we need to keep in mind so that we avoid, making it fall heavy on us. So, friends, I hope you're taking notes. And I would just like to greet our friends who already joined us. Hi, Rag. He says, "Good morning, Nipa and Prashanti." Well, good morning to you, Rag. On our end, it's already afternoon. So, good afternoon to folks. Good evening. Thank you so much, everyone, for joining us. And we're looking forward for you to participate also with your questions. And we have Seema Patel. Seema, stay with us. We will take up your questions. But for now, we will head on with some of the other questions which I have also for you, Prashanthi. And if you could tell us, if it is allowed for the same person to be entered into the lottery by more than one employer.
Um, yes, you can be. And um, again, Nipasa, I don't want to talk about the lottery, so let's
Okay,
try to avoid the registration questions. But
sure.
yes, it is. It is. You are allowed. A beneficiary can file as many lottery petitions as they want, but a petitioner cannot file twice for the same beneficiary.
Okay, okay. So, all right, then let's go on with our next question, Prashanthi. And this is if you could tell us if can an H1B cap petition be filed for a future job position or should the job exist right now?
That's a good question. So, with reference to that, um, yes. Um, Sorry, what was your question again? I was just sorry about that.
I was asking if, the question is, can an H1B cap petition be filed for a future job position or should the job exist right now?
Okay, got it. So, with reference to filing any H1B petition, whether it be cap or non-cap or a transfer, an extension, or an amendment, you have to show that there's a bona fide job offer, and you have to show that the bona fide job offer exists as of the time of filing the H1B petition. So, while the petition can start in the future, so all cap petitions can only start as of October 1st because that's when the new fiscal year starts. But you have to show that you have a job for the person as of the date of filing, even if it's a start date of October 1st. So, to give you an example, if you are a consulting company, you have to show that you have a purchase order or a work order or a contract from the client where the person is going to be placed, showing a start date of October. But the contract should have been signed as of the date that you're filing the petition. So you should already have work. You cannot tell USCIS that, I don't have a contract right now, but I will get a contract in October or November, or I will look for a contract once the person gets on my payroll. That's called speculative employment. So that's not allowed. So you have to show that you meet all the requirements, whether it be employment or the other requirements, uh, of the H1B petition as of the date of filing the petition.
Okay. Thank you so much, Prashanthi, for taking that up and for clearing some of the doubts maybe even our friends have out there. And hi, Jadav. Thank you for joining us with your question. We will take up your question very soon. And I also want to tell folks out there that if you haven't as yet subscribed to our channel, subscribe now. I hope you're not waiting too long or procrastinating. Subscribe now and ring that bell icon so that whenever we have discussions like these, you are notified and you can join us with your questions. Also, best thing is that you have this opportunity to take where you can call in and ask your questions to the attorney directly, and the number is 425-436-6335, and the access code which you'll have to dial right after the number is 988-888. So join us. Okay, Prashanti, now I have this next question for you, and that is, well, now that the H1B cap registration is over, what are the next steps for employers and selected candidates, and how can they prepare strong petitions before the filing deadline?
Next steps for employers, if they've already been selected, is filing the H1B petition, and ensuring that um meet all the requirements, as I just said, towards getting a H1B petition approved. So, in order to prepare a strong petition, you have to meet all the basic requirements of a H1. Um, and of course, as I said, you have to avoid the package coming back from the mail room, and we already discussed in what instances it can come back. But with reference to the substantive requirements for a H1B petition, you have to know what those are in order to prepare a strong petition. So, first thing is that you have to have a job that is a specialty occupation, that is the job that requires a bachelor's in a specific field. And you have to be able to prove that your job requires a bachelor's in a specific field. And there are many ways of doing that. One of them is just going to the Department of Labor website, which is the Occupational Outlook Handbook. This is available online as well. And you can look at the various positions and that are listed in there and what the job requirements are for those positions. So and then you have to make sure that, um, as the other half of the specialty occupation requirement, you have to make sure that the employee has the degree that's required for the position. So you have to show that the job requires a degree and that the employee actually is qualified for that particular position. So that's a specialty occupation part, which is an essential part of filing a H1B. And with reference to the specialty occupation, make sure you uh, produce enough documentation to convince USCIS that it is a specialty occupation. So that's one way of making your petition strong. And that information is, giving a strong job description, giving a detailed, specific job description, showing that the job is complex enough to require a bachelor's in a specific field. For example, if you're doing a bachelor's as a software engineer, if you're doing a petition as a software engineer, you would put in a job requirement, a job description showing that the complexity of the job. You would say design, develop programs, that kind of thing. You would use the word design and develop. You would use the word analyze, anything to show that the job requirement is complex. You wouldn't use the word test or because testing is not considered to be um, a high level requirement in the IT space. You wouldn't necessarily use the word program, because programmers, again, don't require a bachelor's degree for a programmer, just a computer programmer. So you would avoid using those kind of words, and you would use design, develop, analyze, that kind of description when you're giving a job description. So a strong job description, a detailed job description with examples really helps your petition and helps to show that your position requires a bachelor's degree in computer science. Just giving you that example of a software developer or software engineer. So and you'd also make sure that, as I said, the job cannot be speculative. So one is specialty occupation, which we covered. The second part is speculative employment. So you have to make sure that you show that you have a requirement for the job, even if it's a future requirement. So in order to show that the job is not speculative, you would submit documentation such as a contract, a work order, an MSA, right? So that's the second part, showing that providing strong documentation to show that the job is not speculative. Third, documentation to show that you qualify for the job, for the specialty occupation job. So you would submit your degree copies, all your transcripts. Just a degree copy is not sufficient, because it does not actually show what subjects you learned, and so the officer cannot see whether the subjects are related, the courses are related to the job description or not. So you would put in all your transcripts, you would put in your degree copies, you would put in an evaluation of your degrees if you have a foreign degree, because again, you don't want USCIS to speculate whether the foreign degree is equivalent to US degree or not. So that in order to avoid that, you would put in an evaluation from an accredited evaluation agency, showing that your degree is actually equivalent to a US degree. And then if you're filing a change of status, even if it's a CAP petition, last but not the least, you have to show that you're maintaining status. And in order to show maintenance of status, you would put in documentation to show the status. If you're on F1, you would put in a letter from your school showing your maintaining status. If you're on OPT, you would put in your EAD document and a letter from your employer where you're working on EAD. or you could be putting in pay stubs to show that you're actually gainfully employed on a STEM OPT if you're on STEM, because on STEM it cannot be you cannot be work that is not paid. It can't be voluntary work. It has to be paid work. So you'd put in your pay stubs. If you're on CPT, you might want to put in documentation to show whether your college requires you to work while you're studying. Is it a work study kind of requirement? And you get credit for the work that you're doing. You put in that kind of information. So this is the kind of documentation that you can put in to show that in order to prepare a strong petition to show that you qualify for the H1 and to avoid an RFE.
Okay. There you go. Thank you so much, Prashanti, for the detailed explanation, and I hope that folks out there were already taking notes. And I think we should take up a couple of questions also from the audience so that they don't feel like they're ignored too much. And folks, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Find us not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Connect with us. So now I got this question from, let's take up Seema's question. The first question we have is, I've been hearing about people getting their H1B petitions rejected because they didn't meet the cap requirements. How strict are these rules, and can anything be done if a petition is rejected due to missing the cap?
Uh, you cannot even file a petition if you have not registered and being selected in the cap. You cannot file a petition after the period that you're supposed to file. That is, you're given 90 days. So you have to file within 90 days, and there's nothing you can do really um, if you filed after, unless you're able to show that you filed on time, but for some reason USCI has lost your petition. Even though I have done that last year, and we filed a few petitions even after the deadline, and we filed them online and they were accepted, but they were actually filed on time initially, but there was some issue with the petition, and it came back, and therefore we were able to refile it. So sometimes USCIS might take that into consideration, the fact that you filed it and there was some issue with FedEx delivery, and for no fault of your own, it didn't get delivered on time, etc. So it's always worth a try. And I think that's what SEMA is asking, whether if you miss the date filing the cap and it gets rejected because of that, can you refile? Yes, I've done that, but you can't always depend on USCIS accepting those kind of petitions. Um, if they didn't meet the cap requirements, that really depends on what you mean that they didn't meet the cap requirements. If it gets denied after an RFE because the H1B requirements were not met, maybe you'll have a chance to respond before it gets denied, because you will most probably get an RFE. Um, and then you can submit your explanation in an RFE, or hopefully make amends when you're responding to the RFE. Of course, there are some things that you cannot make amends on, such as if you already have an LCA approved, and if the LCA was not filed correctly, you cannot file a new LCA at that point of time. But rejections also, SEMA, with reference to mailroom rejections, you can refile, resend the case if it gets rejected in the mailroom. But remember, this has to be sent out before the 90 days period that is given to you. If you get the package back for some reason after the 90 days period, then as I said, you can try sending it out, but you can't expect always to be successful in those cases. It really depends on a case by case basis.
Right, right. Thank you so much, Prashanti, for taking that up for Seema. And Seema, I hope you got your answers. If you have more clarifications to make, kindly keep commenting with your questions. So this next one is from Jadav, and he's saying, if I apply for an H1B under the cap and my employer gets audited, what should I be ready for in terms of paperwork and extra checks? Is that something I should be concerned about?
Yes, because if your employer gets audited, And these are called FDNS visits. And this is a good segue into a little bit some information on FDNS visits. So this is the fraud detection unit of the USCIS. And after cases get approved, they sometimes conduct audits, and they have in-person audits. So they come to the office. They might call the beneficiary to ask questions as to what kind of work you're doing, who you're working for, who the client is, what your work location is, and they might ask the same questions of the employer as well. So they want to make sure that you are maintaining your status as per the LC approved LCA. So they want to make sure that you are at the location as required by the LCA. You are getting paid the prevailing wage as required by the LCA. So they often do these checks after the fact, after the approval, to make sure that you're, maintaining status. And you have to be aware of this, because if FDNS site visit doesn't go well, then they can ask USCIS to revoke the petition, and then you'll fall out of status. So it is important that you speak to your employer if an FDNS officer contacts you. Speak to an employer, be on the same page as your employer before you actually talk to the officer. Be aware, take a copy of the entire H1B petition, be aware of what was submitted, what your salary is, that you're getting that salary, what the work location is, maintaining everything as per the terms and conditions of the H1B petition. So, yes, it's important that you know what is in the petition and that you maintain it and you following
Very,
everything as per the petition. Yeah.
yes, yes. Thank you, Prashanti. Thank you for taking that up and for the detailed explanation. It seems like every point is so important. I really hope that friends out there, you're not missing out on anything. But the best thing is that you can always go back and rewatch even after this live stream has ended, and that you can do by watching it in our space. Our handle is at Immigration Talk Show. Don't forget to subscribe to our channel. All right. So Rag, hi again. He has a question for us. So Rag is saying, can I manage my startup as a CEO on H4 no EAD if I'm not taking a salary?
I suggest you don't do that, because on H4, you're not supposed to be working, and managing your own company is working. So you should wait until you get your H4 EAD.
Okay. All the best, Rag, and I know you will get it. So go apply for it. Thank you, Prashanti. Now let's take up this next one. This is from Nirav. Hi, Nirav. Thank you for joining us here on YouTube. And Nirav is asking, how does the H1B cap lottery process impact the priority dates of petitions? Are there selected that are selected? Sorry. Let me take that again. How does the H1B cap lottery process impact the priority dates of petitions that are selected? And what are the implications for petitions that are not selected, particularly in terms of maintaining the beneficiary's immigration status and eligibility for future cap filings?
I don't understand what Nirav means by priority dates, because the priority date is usually used for green card petitions, not used for H1Bs or for registrations. But trying to decipher what Nirav is asking, um, once your H1B lottery is selected, um, then you file for the petition, and uh, whoever files a petition first, it's first in, first out. So
Mhm.
people who file their petitions earlier will get approvals, or they will process their cases first. Um, for petitions that are not selected at all, then you can try in the next lottery, and you could be selected. It does not in any way impact, your next lottery, because the lottery system is a lottery. It's completely random. So it doesn't matter how many times in the past you have applied for the cap lottery.
Okay, that's interesting. Thank you so much, Prashanti, for taking that up, and thank you, Neera, for participating with your question. And
Also,
yeah,
to the beneficiary's immigration status, if you're not picked in the lottery, then your status remains whatever your status was. It's status quo, basically. You have to continue to remain in status. If you're not in the country, of course, then there's no question of status. If you get picked in the lottery and you file your H1B petition, then as of October 1 or whenever your H1 gets approved, then your status changes to a H1, whichever is later. So that's how it impacts your status.
Sure. Okay, thank you so much. And friends, don't forget that, this is your opportunity to join us with your questions. And you can do that by dialing this number 425-436-6335, and the access code is 988-888. Also, best thing is you can comment your questions and we will be happy to take them up. So just check us out, not just here on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. So yeah, now coming back, Prashanthi, to some few of our questions before we head on with the other questions from our audience in Facebook. Well, I have this next question, and that is: are there any restrictions on changing employers after being selected in the H1B cap?
Yes, that's also a good question, actually, because a lot of people ask me that question. They file for registration through some employer, and that employer doesn't want to file a H1B petition, and they think that they can now file a H1B petition since they're selected in the lottery through another employer. So that's not possible. The lottery and the selection is tied to the employer that did the registration. So if the registration gets selected, then the employer that's filed the petition, filed the registration, must file the petition. Of course, once the petition is filed and approved and you started working, you can always file for a transfer of the H1 from that employer to another employer. So if you do want to move employers, that's the way to do it. But you cannot do it before, you know, before you start working for the original employer.
Okay. Yes, many people actually ask this, and sometimes it's like they want to change from employer A to employer B or to employer C, and it becomes difficult, I think, right, Prashanti? And they're not allowed to do so.
Correct, yeah, because the registration, as I said, is tied to the employer. So, unfortunately, if the employer is not willing to file a H1, and that's completely possible nowadays because they do the registration in anticipation that there will be work available because they don't have to show necessarily the work availability at the time of registration. And then they are not able to file the H1B petition because they're not able to find work,
Mhm.
because something has changed, because the market has changed. And we see a lot of registrations are wasted because of that. And that's the reason USCIS sometimes conducts a second lottery, because even though they're selecting more people than they should, even in the first lottery, they're selecting about 100,000 or 120,000 when we only have 85,000 slots. They're
Mhm.
accounting for that, but their accounting falls short because many more people don't file, and they sometimes that's why I have a second lottery.
Right. You think it's going to happen this time as well?
We have to wait and see. Even if there is a second lottery, it's not going to be big numbers. It'll just be a few
For a
cases.
smaller number of people. Let's see. Let's see, friends. We don't know what's going to happen, so we'll just have to wait and watch about the second lottery. But now let's concentrate on folks who got selected in this lottery and who are planning their next steps or are already on it. So, yeah, now next question for you, Prashanti, is if you can tell us, are there any restrictions on changing? Oh, sorry, we took this. So, is it okay for a candidate to work on CPT or OPT while waiting for H1B approval?
That's also a very good question because I've been receiving that, a lot of people asking me that question. A lot of people think that once they get selected in the registration, that they should work for the that company who filed their registration, and filed their H1 maybe, even before the October 1st or before the H1 gets approved, they should be working with them on CPT and OPT. It's not necessary that you should be working for them. You could be working for another employer and start working for this employer once the H1 gets approved after October 1st. So you could be working for a completely different employer on CPT and OPT. But your question was more, do we have to work on CPT and OPT once it gets selected? Yes, you have to continue maintaining your status until you change status, until your change of status gets approved. You have to continue maintaining your status on F1. And if that means that you're working on OPT, then you have to continue maintaining your status on OPT. And if that means having to work because STEM OPT requires you to, uh, you know, uh, work for money, then you should continue. You have to continue doing that in order for your H1 change of status to get approved. Otherwise, they'll say that you're not on valid F1 status and they will only approve your H for consular processing.
Right, right. Thank you, Prashanthi, for taking this up as well and for the detailed explanation. Now let's go on to our next question, and that is, what happens if an H1B petition is selected but later withdrawn by the employer? Can the candidate reapply? Like you already touched on it just now a bit, but can they reapply?
If the registration is selected but then withdrawn, is that what they said?
If the H1B petition is selected but later withdrawn by the employer?
Ah, well, depends. If is it withdrawn before the H1 gets approved, then you're not considered to be cap exempt. You'll have to file again for registration next year. But if it was withdrawn after you start working for them, then you will still be considered to be cap exempt. And then you can file your H1 using that 60 days grace period, you know, and find another job within the 60 days. Or if you already have another job, just file for a transfer.
Okay.
And it is cap exempt. So.
Yeah. Well, thank you again, Prashanthi, for taking this up. And folks, if you're resonating with Attorney Prashanthi Reddy, her, taking up each of our questions and patiently answering them so well, why don't you give her a call, or maybe you can choose, for your case as well. So her number is where you can reach out to Attorney Prashanthi Reddy, 212-354-1010, or go email her at prashanthi@reddyesq.com, or yes, go check her out at www.reddyesq.com. And also, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. If you haven't as yet subscribed, what are you waiting for? Subscribe now, friends, and share this with your friends and family who could benefit a lot with all the latest information we have on US immigration. So, yeah. Now let's take up some more of our questions from our audience in Facebook. So, Control, if you can please display some of them, please. Let's go on with them. So we got this first question from an anonymous participant. When you file for I-130, you choose the service center. Do we have the choice? Please help. Thanks.
It's can you choose the service center? No, you cannot choose the service center when you file an I-130. You have to, there is a list of service centers that I-130 goes to based on where your, if you're the petitioner, wherever you're living, uh, based on the state that you're living, you file it at that service center.
Okay. Thank you, Prashanthi, for taking that up. Let's go on to this next one, which says after approval of EAD I 765 and I 485, what is it? What is next? Does I 485 go with insurance of green card? And does the I 130 and when does the I 130 get approved?
Does I-485 go with issuance of green card, and when does I-130 get approved? Um, Yeah, but so usually I-130 will get approved before the 485 gets approved, or both will get approved together. And after the 485 gets approved, then there's an issuance of the green card, because that's when they get the card in the mail. So first you most probably get an I-130 approved. First you might get a 765 approved, which is your employment authorization, because that's given as an interim benefit while the petition is pending. Then you might get an I-130 approved, and then the 485 might get approved, or the I-130 and 485 could get approved together. And once the 485 is approved, you'll get I-797 approval notice, and then you will get the green card, the actual card, in the mail. It'll be mailed to you.
Okay. That's nice. Thank you so much, Prashanthi, for taking that up. And now let's go on to this next one, which says, "Hello, my husband and I are in the middle of process of marriage green card. He is in Mexico. I'm in US citizen. I am the US citizen, and our I-130 got approved, and we are waiting on information from NBC. My question is, as a US citizen, does it affect anything if I decide to get aid, Medical in my case?"
I don't know what Medi-Cal is, but Medicaid. So it doesn't matter that you're getting Medicaid as long as the applicant, the beneficiary, has. Even it may not matter even if the beneficiary doesn't gets Medicaid. But what is important is that the beneficiary should not be considered to be a public charge. The beneficiary would be considered to be a public charge if you know they've as per at least the present definition of a public charge, and that keeps changing again, and it might change again under the Trump administration because under his previous term they had expanded the meaning of public charge. But presently, public charge means a person who has received actual money for sustenance, and a person who has received long term, um, has been admitted long term into a rehab kind of facility at the government's expense. So those are the
Okay.
two uh, factors which will disqualify you from getting a green card based on the public charge rule. Um, Also, you as the petitioner will have to have we sponsor them and fill out an I-864, which is the affidavit of support, which means that you have to have enough income to be able to sponsor them, depending on your family size, $25,000 or more. So if you're on Medicaid, does that mean that you don't have sufficient income? Uh, so I'm not sure what it is, but you have to be, if you're not able to sponsor them because you don't have sufficient income, then you might, or you're retired, you might, you have to get another sponsor then, an additional sponsor, a joint sponsor, who will fill out again the affidavit of support and submit their tax return. So as you see,
Okay.
there's many nuances to it. It's not just, uh,
Yes.
they might be, I've answered questions that you might not have asked also because you may not have known to ask them.
Yes, yes. And actually, they've just put up a situation about themselves. So, of course, and I do not know what is Medical. So, thank you so much, Prashanthi, for taking that up. And, I hope that this was sufficient and a good answer for anonymous participant from our Facebook group. Thank you so much. So let's go on to this next one. This is also from an anonymous participant asking, "Hi, I petitioned for my mom's green card in June 2024. She was interviewed 4 weeks ago at Santa Ana office. I-130 was approved the next day, but I-485 is still pending after 4 weeks. Is this normal nowadays?"
Well, a 485 can take a while. It takes 12 to 18 months for a 485 to get approved. So that's how you have to count the processing time. Not from the date of the interview. The interview can take place anytime in between. It's not necessary that the interview will take place at the fag end uh, of the case and then it'll get approved immediately after. So processing time varies. So I would just look at the overall processing time and see whether you're within the normal time or not. So if you've applied in 2024 June, it's still not even a year. I wouldn't worry.
Okay. Well, thank you so much, Prashanthi, for taking this up. And now let's go on to this next one saying, "Hello, I'm looking for an immigration attorney. My husband and I have been married 5 years and we have a house and children. We have filed I-130 and it is being reviewed. However, my husband's I-485 was declined due to not sending the correct documentation. I sent 2022 W-2 and not 2023. We have to appeal with an I 29 209B. They are revoking his EAD to work. Has anyone gone through this? And do you have any recommendations? Do you have lawyers or attorneys that can help ASAP? Absolutely, yes. We have Attorney Prashanthi Reddy here. And Attorney Prashanthi Reddy, what would you like to say to this?
Definitely, you can call me up and I can give you a free consult, and then we can decide, how we can take the next steps. And this is an example of why you shouldn't be filing the petition yourself, because this could be an easy fix and you didn't have to get a denial. It's possible that you can also maybe consider refiling your petition or filing an appeal. You could do either one, and we can look into it and once we know more about your case. Yes, unfortunately, the EAD will no longer be valid because the 485 has been denied. Remember, when you choose between filing an appeal, refiling a case, there are many considerations. So you have to do what is right in your situation. In some situations, it's just easier to refile. In some situations, you cannot refile because maybe the person is out of status and if they're not married to a US citizen. In some instances, it's important to get EAD, so they might want to refile so that they get the EAD again, because a motion to reopen can sometimes take a while. So these are the things to consider when deciding, and also it depends on why it was denied and whether USCIS is likely to approve the case on appeal, or it's a better idea to refile the case entirely. So these are the considerations that we have to discuss before we decide which approach to take.
Right, right. Thank you so much, Attorney Prashanthi Reddy. And well, anonymous participant, if you're watching us right now, you can get in touch with Attorney Prashanthi Reddy on her number 212-354-1010. And her email address is prashanthi@reddyesq.com. And when you do contact her, don't forget to let her know that you got the contact or you watched her here at Immigration Talk Show. So thank you so much, Prashanti, for taking this up as well. And I do have a couple more questions if you have a little more time, maybe.
Sure.
So, Prashanti, this next question that I have for you is if you can also tell us, what happens if an H1B petition is selected? I think we've taken this. So, this
Yeah,
next
we
one. Yeah. How can an employer prove the job, a specialty occupation to meet H1B eligibility?
How can the employer prove that the job is a specialty occupation to meet the H1B? I think we kind of discussed this a little bit
We did.
um, with reference to specialty occupation, but very briefly, you have to show that the position requires a bachelor's degree in a specific field. And how you show that is you can show that it's common in the industry to require a bachelor's degree in a specific major. How do you show it's common? You can print out DICE and Monster job site listings, and you can print out several to show that, look, this is a position, and all these positions require a bachelor's degree in that field. You can also go with the employer's uh, previous practices. So if they've hired a person with a bachelor's degree in a specific field previously for that particular job, you can show proof of that. You can also go to websites like the Occupational Outlook Handbook, which lists positions and um, basically talks about what the common requirements are for that position. So these are three ways where you can show that the job is a specialty occupation. If you're not able to show any of this because maybe the industry generally doesn't require a bachelor's degree, but you require because for some special reasons, then you have to show the complexity of the job and why you require a bachelor's degree and how your job is different from other jobs, and and it's why your job is more complex when compared to other jobs, and therefore you might require a bachelor's degree in that particular field.
Okay. Okay. Thank you, Prashanti, for taking that up. And well, before we go, if you could also tell us about what should employers avoid when offering remote or hybrid work in an H1B cap petition?
It's perfectly okay to provide remote work or hybrid work. You should put all the work locations in the LCA. So please make sure you do. Please make sure you pay the salary that is the highest among all the locations. That's a requirement. Also, what you have to make sure of is that you keep track of your employer. So if they're moving houses, they might move without telling you, and then you would not have filed an amended petition because the work location has changed. Most probably, salary has changed. Then they fall out of status. So please inform your um, employees that they need to let you know, and you need to file an amended petition before they change their home location if they're working out of home. You also have to be aware that if it's a home location, that the offices can come and visit uh, your home. And you have an LCA posting requirement at the work location. So if that's your home, you have to post it on your fridge or wherever it is that everyone can see. I know it sounds ridiculous, but that's a requirement. And you have to be ready to welcome the officer into your home, show them your workspace, and answer any questions that you have if there is an FDNS visit.
It's very interesting, and thank you so much, Prashanti, for taking that up. Absolutely important. I hope that friends, you are taking notes and are able to follow what we have been discussing. And thank you so much, Prashanti, for taking that up as well. Very patiently answering each of our questions. So I think with that, we have definitely covered almost all. But still, if we have anything left, Prashanti, maybe you would like to give an end note before we leave.
Um, File your H1B petitions carefully. Use an attorney or an expert to file them. You have won a lottery, and it is really a lottery in the true sense because it's difficult to get through. So don't waste that opportunity. Make sure you file your petition correctly and in a timely manner.
Sure, absolutely. Very, very nice of you to say that and remind friends out there. So thank you so much, Prashanti. It was great having you with us today. And I hope to see you soon again.
See you again next week. Thank you, Nipasa.
See you, Prashanti. Thank you. Have a great day. And folks out there, you can also contact Attorney Prashanthi Reddy. And in case you especially want a one on one discussion, every case is different. So why not give her a call? Her number is 212-354-1010. And you can also email Attorney Prashanthi Reddy at prashanthi@reddyesq.com. And when you do, please do not forget to mention that you watched her here on Immigration Talk Show here on our channel. And she'll be happy to, assist you. And well, that said, you can also subscribe to our channel. Don't forget to do that. Our handle is at Immigration Talk Show. You can find us not just here on YouTube, but also on LinkedIn, Facebook, X, on Instagram. Connect with us, stay connected with us. And yes, this is it for now. You can also contact me, by the way, in case you have any questions, which we will be happy to address, with an attorney. And my number is 408 335 6444. You can call me. You can also WhatsApp me. That's my WhatsApp number. And yeah, you can also email me at nipa@staffingly.com. So this is it for now. But don't go anywhere. Keep watching Immigration Talk Show because there's a lot more coming here. And there's so much good and latest information on US immigration that you really do not want to miss out on. So keep watching and bye for now.